Good evening, everyone, and welcome to this meeting of the National Jewish Assembly. For those of you who don't know me, my name is Gary Mond. I'm the chairman, and we're delighted. We're now hosting meetings roughly once every 2 weeks, and tonight's event is on the issues of demystifying the International Court of Justice's case against Israel. We're going to hear from 3 key experts who have tremendous insights into what is happening and projections going forward. I'm going to begin by introducing the three experts who are each going to talk for 6 or 7 minutes, something like that. Then I'm going to kick off with a couple of questions for the expert, and then I'm going to throw it open to everyone else to ask questions. Can I say to you that there is in your, at the bottom of the screen, you will see a button which says raise hand. Can I please ask you, if you've got questions, to raise your hand? And don't feel you have to wait till we start the questions to raise your hand, because it's good from my perspective to know how many people want to ask questions, because that dictates how many questions I will ask. The more hands that are raised, the fewer questions I will ask. So without further ado, let me now introduce our 3 guest speakers. Our first speaker will be Andrew Tucker. Andrew's an Australian-Dutch international lawyer. He's director of the Hague Initiative for International Cooperation, which is a collective of international lawyers based in The Hague. And he's worked since 1988 as an advisor and consultant to private companies, governments, and semi-public entities in various fields of international law. He's a legal counsel to the European Coalition for Israel, and he's co-author of Israel on Trial. Our second speaker will be Natasha Hausdorff. Natasha is a barrister in London, a director of UK Lawyers for Israel. Natasha previously worked for Skadden Arps in London and Brussels, and she clerked for the President of the Israeli Supreme Court, Chief Justice Miriam Naor, in Jerusalem. Natasha speaks frequently on international law, foreign affairs, and national security policy, and she's been a regular on British and foreign media since the massacres of the 7th of October. Our third speaker is Arsen Ostrovsky. Arsen's a leading human rights lawyer who currently serves as CEO of the International Legal Forum, which is an independent Israel-based proactive global network of over 4,000 lawyers and activists in 40 different countries, standing up for Israel and leading the fight against anti-Semitism, BDS, and terror in the international legal arena. Arsen has spoken before the UN Human Rights Council in Geneva, in parliaments across Europe, and to audiences all over the world. So it's my great pleasure to invite our first speaker to address us, Andrew Tucker. Andrew.
Thank you so much, Gary. Am I unmuted? I think I am. Well, good evening, everybody. Lovely to be with you. What I thought I might do, with your permission, Gary, is just take a step back and paint perhaps a little bit the bigger picture that this situation is taking place in. And I'm sure Natasha and Arsen will zoom in and talk about the case specifically. We're talking about the case of South Africa against Israel in the International Court of Justice in The Hague, which was brought by South Africa at the end of December last year under the Genocide Convention, claiming that Israel is committing genocide of the Palestinians, and not just in the Gaza Strip, but actually since 1948, this has been the Israeli agenda, is to kill the Palestinians, destroy them, to eliminate them in whole or in part. That's what genocide is all about. So I think we need to see this as really just another piece in this continuum of 100 years of lawfare relating to the Jewish people and the land of Palestine. We're now 2024. It's almost exactly 100 years, just a little more, since the mandate for Palestine was created by the League of Nations, 1922. After the First World War, the collapse of the Ottoman Turkish Empire, the German Empire, and all the empires that kind of disappeared. And a whole new world order was created for the Middle East and large parts of Africa and Asia Pacific. It was really the beginning of a whole new legal world order. We moved from empires to states. States were created. Before that, you had European states, but not many other states in the world. And all of a sudden, we had states. So states were starting to be created in the Middle East. And the Middle East comprises a whole bunch of many, many different ethnic people groups, right? Tribes, families, nations, call them what you will, peoples. Not just Arabs living in the Middle East. The Jews have been living in the Middle East forever, since they were created as a nation. Their birthplace was in the very heart of what became known as Palestine. And Jews have always been living in Palestine ever since Abraham. And they are one of many other people groups living throughout this region. If you look at the modern countries of Syria or Iraq or Lebanon, they comprise many people groups. But these states were created with artificial boundaries established by the colonial empires, who won, the victors of the First World War. They got the right to decide what to do with the Middle East. And so they created a mandate system. And basically, they had to kind of work out a system that was going to keep everybody happy. And in that process, they decided very firmly that the Jewish people have a right to re-establish their national home in Palestine. And they created the mandate for Palestine for the very purpose of fulfilling that objective. Palestine, therefore, is the location of the Jewish national home. Winston Churchill, in his wisdom, decided to keep the Arabs happy, he would create an Arab-Palestinian state. It became Transjordan. Later became the Hashemite Kingdom of Jordan, we know today, was the first Arab-Palestinian state. And everything west of the Jordan River, the remaining part of Palestine, was intended for the Jewish national home. Now, I say this because ever since then, there's been a legal war against the Arab world, many of them who rejected this idea that the Jews should have any sovereignty, any national home in the Middle East. And they've used every legal weapon they can think of. They reject the mandate, they reject the Balfour Declaration, they reject everything that came out of it, and they reject the legitimate existence of the Jewish state of Israel. And that's why we talk about normalization today with the Arab world. I mean, it's kind of bizarre to think you have to even have normalization. The Jewish state should be recognized as a legitimate, sovereign, equal member state of the international community. And yet the Arab world, by and large, still struggles to accept Israel's existence. So after the Second World War, and I'm going to very briefly wrap up, Gary, don't worry, I'm not going to lecture for the rest of the evening, but let's not forget, 1939 to 1945, not only in Europe, but also Hitler, in concert with the Grand Mufti of Jerusalem, was intending to eliminate and destroy the Jewish people in their entirety from the face of the earth. And he got a long way in achieving his objective, the Shoah, the Holocaust. And out of the Holocaust, we had a new reinvention of the global legal order. And we created the modern system of international law, Geneva Conventions, Genocide Convention, the United Nations Charter. All of this was new, and it was intended to create a system where all states are equal and where all states are recognized and peoples have legitimate rights of self-determination. And this would create peace and prosperity on earth. And unfortunately, this has not happened. And ever since 1945 and the creation of the State of Israel in 1948, the enemies, the opponents of the Jewish state, have used these instruments to attack the State of Israel. They're using the UN system. And so I think this Genocide Convention case that South Africa, I mean, what does South Africa have to do with Israel? Well, South Africa is deeply in bed with Hamas, with Iran. It has always been a close ally of the PLO, the Palestine Liberation Organization, which to this very day maintains as an element of its charter the elimination of the State of Israel. This is the entity that the international community expects Israel to negotiate with. Now, South Africa, acting, I believe, on behalf of the PLO and the Arab world, has taken these proceedings under the Genocide Convention and the State of Israel that was created out of the ashes of an attempted genocide, is now being accused of genocide of the Palestinians. The Palestinians have rebranded themselves as being the indigenous people of this territory, where in fact it's the Jewish people who are the true indigenous people. So we're seeing the world, the legal instruments turned upside down on their head. And I think the court failed. And I'm sure Natasha and Arsen can explain this in more detail, how the court failed, I believe, to see through this mirage, see through this, this misuse of the legal system to achieve, I think, illegitimate ends, namely the destruction of the State of Israel. Thank you.
Thank you so much, Andrew. Natasha.
Well, thank you, Gary. It's wonderful to be back with you in the NJA, and a real pleasure, as always, to be with Andrew and Arsen, who I have had the great privilege of knowing for many years in the context of the fight to highlight and combat lawfare. And I'm very grateful for their friendship and allyship in that endeavour. And I'm sure many in our audience have heard me talk previously about lawfare, this phenomenon of the abuse of international law, specifically against the State of Israel, and as Andrew has said, with the purpose of seeking to ultimately annihilate Israel, in this particular instance, do the bidding of the terrorist organization Hamas. When I look at the title of this session and reference to the case at the International Court of Justice, absolutely it's the case that South Africa has brought that has most of the current attention, but there is in fact more than one case currently at the International Court of Justice against Israel. And the next one, as it were, to consider, the hearings will begin on the 19th of February, so this coming Monday. It is in the context of an advisory opinion that is being sought from the court by the General Assembly. I'll say a few words on that before returning to the South Africa case. An advisory opinion, of course, is not a legally binding opinion, but just like the previous advisory opinion sought against Israel in 2004, the so-called Wall opinion, the finding or opinion of the court in that particular context does carry weight and can have a serious impact, as that previous determination against Israel's security barrier did. And the case that is being brought for this opinion by the General Assembly, actually, the understanding of that benefits enormously from the background and the overview that Andrew has given of the historical origins, the indigenous rights of the Jewish people, because the request for a legal opinion is entitled as follows: legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. And what we saw in December of 2022 in the request from the General Assembly was a plethora of allegations against Israel. The General Assembly didn't ask the court to make an assessment of those allegations. It in fact asked the court to take those allegations of illegality and wrongdoing as given. And it simply asked the court, what are the legal consequences of all of Israel's terrible behavior? And so that is the context of the hearings that will be starting on Monday. And no doubt there will be a great deal of media coverage, even more so in the context of the 7th of October and the war against Hamas than there might otherwise have been. So that will be imminent. And the other sort of more recent development that we have seen in relation to the case that South Africa has brought, this is not in the context of an advisory opinion, this is a bilateral state-to-state case, which does have binding legal consequences on the state parties. South Africa brought this case alleging genocide against Israel. It's important to understand that this was not a coincidence, and it's not because South Africa really displayed any legal or factual merit in its allegations of genocide. The reason South Africa chose to bring the allegation of genocide is because it provides a legal hook through which it can bring Israel under the jurisdiction of the International Court of Justice. Both Israel and South Africa are signatories to the Genocide Convention, and as a result, if any state says that they have a dispute with another member of that convention, that dispute can be heard before the International Court of Justice. And that is why you saw Israel engaging with the proceedings, the preliminary hearing that we had in the last few weeks, where South Africa was seeking provisional measures. Israel hasn't engaged previously with many of the international legal organizations that have sought to, quote unquote, put it on trial where there wasn't a jurisdictional basis to do so. So here, South Africa was able to demonstrate a form of jurisdictional basis simply on the matter of fact that Israel and South Africa are both parties to the Genocide Convention, and it has brought this case. But in my respectful opinion, it is not a case that has any merit whatsoever, and the aims that South Africa has sought to achieve are political and of a public relations nature. And we have seen the intense coverage of this case and how South Africa has played to the gallery throughout. In particular, of course, on the Thursday of the oral hearings in which it presented its case against Israel and made every sort of allegation that you could imagine, blood libel after blood libel, including allegations of war crimes and apartheid, despite the fact that they bear no relevance to the hook that South Africa had placed this case on, the issue of genocide. I'm sure we'll come on to talk about the grotesque the grotesque nature of making an allegation of genocide against the real victims of genocide on the 7th of October. But the last thought that I will perhaps leave you with is to do with the way that the order that the court passed a few weeks ago in January, issuing provisional measures, how that has been utterly misrepresented by South Africa and by the media. It was celebrated by Hamas, of course, but it's important to clarify that the order that the court gave on no account made any substantive findings against Israel, and on no account did it make even a plausibility finding that Israel had breached the convention. The court steered well clear of that. What it did was decide whether or not South Africa had brought a case which presented, quote, plausible rights. Now, plausible rights has never been explicitly defined by the court, but over a series of previous cases, which the court has reference to, it is seen to be an extremely low standard at which the court will consider whether or not provisional measures can be made. And in that context, the best way I can explain it is as follows. The court considered whether the case that South Africa brought under the Genocide Convention could plausibly fall under the Genocide Convention. That's pretty tautologous, you may think, but that is essentially on a plain reading of the order where the court fell on its consideration of the issues. It didn't consider the substantive merits of the case. It didn't even consider what Israel had said in response. And on that basis, it made provisional measures which are essentially repeating the existing legal obligations upon Israel. So much so that the Ugandan judge, Sebutinde, called out these provisional measures as utterly redundant because they simply restated the existing legal position, but for the fact that the court has asked Israel to provide a report to it on progress. So taking into account the fact that those provisional measures were utterly redundant, that in fact reinforces the reading, the fact that the court has made no findings here, and the fact that the order that it put out essentially says nothing. That blank sheet of paper has, however, provided the perfect opportunity for South Africa and others to project their own malicious indications of what they say the court has found, even if they're not borne out by the facts. And there we come back to the real motivation behind this, which is PR, propaganda, and lawfare.
Thank you, Natasha, so much. I'm going to ask Arsen to address this just a moment. I just want to remind you, if you've got questions, please put your virtual hands up. Okay, I've got David Lazarus so far, but please, more of you put your virtual hands up. Arsen, over to you. Welcome.
Thank you, Gary. It's, I must say, it's a great pleasure to speak along with my two distinguished colleagues. And if we're going to go in Hebrew right to left, then I'm speaking first, so I'll take that as a compliment. But it is a tall order going after Natasha and Andrew. And, you know, I think even though, you know, we got a tall order ahead of us, both as a state and as a people, but I think we have some incredible advocates in every sense of the word that are here on this panel with us in our corner. And of course, the incredible work that you, Gary, and your organization are doing in standing up for Israel and correcting the lies and mistruths and making certainly the case for the Jewish state and the values of democracy and rule of law and human rights and freedoms that we indeed do cherish in the UK, which is not the easiest of circumstances in the best of times, put it that way, let alone now. And I think certainly as you know, from speaking from Israel, we're certainly also not oblivious to the effect this is having, this case, these proceedings, the perversion of the discourse that we're seeing on the streets of London in the UK with some of these rallies and, quite frankly, calls for genocide, violence, incitement as well. So I think you know, we've got to look at that likewise. There really is very little for me, I suppose, to add, because I think both Andrew and Natasha have done an incredible job both putting it in context and touching on some of the key legal issues. But you know, perhaps sort of I might try and put it a little bit more sort of context, sort of from my perspective. So I think along with Andrew, we were both actually in the Hague during the hearings, and before I flew out, my daughter, who just turned 7 years old, asked me why I'm going, because it was a longer trip. And, you know, there's only so much that one might want to explain to a barely 7-year-old girl about genocide and what is happening. So I try to explain it in very generic terms. And she then turned to me and she said, Abba, bear in mind, 7-year-old girl, Abba, you know what? They don't have to like us, but they shouldn't say things that are not true and not nice. And I thought, you know what? Here's a 7-year-old with more common sense than all these so-called experts, talking heads, judges, and everyone else who all of a sudden overnight has become an expert on the Genocide Convention and international humanitarian law. 7-year-old, she gets it. But, you know, having been there in The Hague, having seen the proceedings, also having seen the response, and you know, there are also crowds. We had on the Thursday, we had a pro-Israel rally with 2,000 plus people. Andrew, you were instrumental in arranging that. You know, it was an incredible show of support and solidarity. There were hostage families there. It was a call for unity, a call for peace, a call for the release of the victims. Incredible. And then sort of the next day, seeing this a literal split screen with a Palestinian activist outside The Hague at the same time as Israel was presenting with literal calls for genocide, for intifada, to free Palestine, posters superimposing Netanyahu and Hitler outside. At the same time Israel is defending these outrageous proceedings, you have literal calls for genocide outside this very hall. What we saw in The Hague in those 2 days, and essentially from the beginning of the end of December when these proceedings started and up to now, can I think only be described as both a gross travesty of justice and a cynical perversion and demeaning of the very term genocide itself. A few days after the hearings, I was invited by a news station in the US to talk about the hearings and my experience. I went on, and this is a mainstream station. The first question they asked me is, I quote, why is the Jewish community so sensitive to charges of genocide? Why is the Jewish community so sensitive to the charges of genocide? The question struck me, in part because it wasn't meant in a malicious way, partly because it was also born out of naivety and not understanding both the meaning of genocide, its term, and why it is, in fact, why we are so sensitive to charges of genocide. The very term genocide was developed by a Polish Jewish jurist, Raphael Lemkin, to describe the very massacre of the Jewish people in the Shoah. And here it is now being weaponized, instrumentalized, subverted against us in the wake of the single greatest massacre of Jews since the Holocaust itself. If anyone, quite frankly, ought to have been on trial here, it's not Israel, a liberal democracy that has gone above and beyond our obligations of international law, in discharging our obligations on international humanitarian treaties, in seeking to minimize and quite frankly avoid Palestinian casualties far more so than Hamas, which is committing a double war crime of hiding behind Palestinian civilians whilst targeting civilians in Israel. But not only is it Hamas that ought to have been on trial, though, because we have to remember Hamas are the ones that are very open in terms of their genocidal ambitions. One only needs to look at their charter. These very same ambitions which they acted out on October 7th, when they infiltrated Israel and massacred, burnt, raped, tortured, mutilated, abducted over 1,200 people who were killed, massacred, and we have another 134 still being held captive to this day. Barely 2 weeks after that, you saw one of the senior Hamas officials, Ghazi Hamad, come out on an interview with LBC, the Lebanese LBC, not your LBC, albeit quite frankly, sometimes I'm not sure there is much of a difference. And he said that, and I quote, "We will continue this over and over again until Israel is annihilated." And yet you still have the audacity of South Africa, which, by the way, here is, let's just be quite frank, acting essentially as lead counsel for Hamas and the Iranian regime, seeking to put Israel in the dock. A point that was made actually during the hearings, and I think it's important as well by the Israeli representatives, is in fact South Africa themselves ought to have been in the dock, because South Africa is in breach of their own obligations under the Genocide Convention in embracing Hamas, in embracing Iran. Even now, to this very day, they are still welcoming them, embracing them. The South African Justice Minister was asked on the steps of the Court of Justice, do you even consider Hamas a terrorist organization? And they quite blankly said, no, because they don't operate on South African soil. Now, the effects and the ramifications of what we saw there in these hearings are very real. We are seeing an intense pressure now and calls for a ceasefire. We have seen only yesterday, you have Joseph Borrell, the EU Foreign Policy Chief, already calling for an embargo on weapons and arms to Israel. We saw a case just in the Netherlands, literally in the last 24 hours. We will be seeing increasing calls for punitive and diplomatic measures in Congress, in parliaments elsewhere around the world. And one of the biggest, or I suppose two of the other biggest effects is you will see basically fuel poured on the anti-Semitic fire in the streets of London, in Europe, in North America. But what you also see is that democracies like Israel, like the UK as well, becoming hamstrung in our defense against jihadist terror. When the threshold, as Natasha said, is so low for countries to initiate proceedings, you can have the most outrageous scenario where, by the way, the Genocide Convention, I think, is the most ratified treaty in the world, where you can have potentially China, Russia, all signatories taking the UK to court over claims of genocide, over actions in Afghanistan, Iraq, and wherever else British forces may be. And I would add one last thing, to look at the real life implications. Barely 5 minutes, I think, before we even went on air, I just got a notification. South Africa has already gone back to the ICC to request an urgent injunction over Rafah, over what is happening there now. We saw the other day with the rescue of the 2 hostages, the necessity of an Operation Rafah, but they are already claiming genocide. They're already claiming breaches of international law before we've even done anything there. So look, at the end of the day, I think, there are only two certainties in life: death and taxes. We can add a third, that Israel will always be found guilty in front of the United Nations. And we have to remember that ICJ is a tool and organ of the United Nations. All that said, at the end of the day, I still think Israel did the right thing in appearing there. The determination might have been known in advance, but we had a legal obligation under the Genocide Convention. But I think more importantly, Israel wasn't only presenting our case to those 15 judges. We knew the outcome. But Israel was presenting its case to the rest of the world, for the rest of the world to hear our case, to hear the absurdity of what South Africa was doing, the perversion of justice, the perversion of law. So we have to remember that we were speaking not only to the judges on the bench, but we're speaking to the broader world. And I think that's critical to note here as well, because we're fighting not only a legal battle, but a war of narratives.
Arsen, thank you so much. To give as many people as possible a chance to ask questions, I'm going to ask the first 3 people who put their hands up to ask their questions, and then I'll hand it over to the panel to answer. So David Lazarus first, then Adam Kershaw, then Denise Lester. David.
Hi, good evening. Can you hear me?
Yes, and can we keep it questions to questions rather than speeches?
It's going to be a question, Gary. Give me 1 second, please. Okay. Do you not believe that if in December, if Trump was to get in, things will change because of the tone of Trump would make things a lot clearer for Israel than if Biden was there? Because Biden seems to be falling and making it harder for Israel's case.
Thank you. Adam.
Hi. So given the genocidal rhetoric that comes out of Hamas, that comes out of the PLO, that comes out of other militant factions, would it be worth, after these hearings, Israel trying to present a case of genocide to the court? And if so, who would they bring the charges against?
Thank you. Denise.
Thank you, Gary. Thank you, panel, for your erudite insights. Am I right in thinking that now that there's a case to answer, the court will look closely at the continuum of the actions of Israel and their methodology in determining whether or not there is genocide, i.e. Whether there's intent and or whether or not there's no intent under the Genocide Convention, because it seems to me that Israel is going to have to document all the steps it is doing alongside, so as to consciously show beyond whatever standard of proof is needed that they are not deliberately engaged in any genocidal activity. And do you have any other comments to add on my interpretation and exposition? Thank you.
Thank you, Denise. Arsen, would you like to go first? And then Natasha, then Andrew. Arsen.
Okay, I'll try and be brief and in order of the questions with respect to the US elections. Quite frankly, I don't think anyone knows what is going to happen. And if they do, I would love to buy a lottery ticket from you, please. Look, in terms of will there be a change? I would think there would be perhaps some change, albeit quite unpredictable. I mean, I think from the beginning, the Biden administration, whatever one might think, certainly from the beginning, provided incredible support. We have to acknowledge that. However, I believe that has certainly waned, and we've seen that only in the last few days. For example, when President Biden said in a press conference that Israel was going, I quote, over the top. Language like that is certainly not helpful. We saw Anthony Blinken just a few days ago add that just as Hamas was, I forget the exact terminology, but it was delegitimizing or use the kind of language that we're using and actions against Israeli people. This must not happen in turn to the Palestinian citizens. And of course, every supportive comment about Israel's actions is immediately followed by, but Israel must follow its obligations under international humanitarian law, as if we're not doing that already, which of course we are. So I think language like that only plays into the narrative that Israel is some kind of pariah, war criminal, and that there was merit to the charges that were brought before the court. Again, I don't know how President Trump will act. We've seen, obviously, with respect to the ICC in the previous administration, that they have dismissed those hearings and actually took some punitive measures, for example, against ICC, the prosecutor preventing their visa entry. I don't know if that will happen, but that remains to be seen. The second question in terms of if Israel will take any action, there's already been, I'm not sure if they will. I'm not sure if that's the sort of kind of steps that Israel does take. But there has been talk at the very least, by Gideon Sa'ar in Israel, who is a former Minister of Justice himself, about bringing a possible case of genocide against Iran. Now, I think that is something that is important and I think ought to be considered very strongly, because if anyone is guilty of genocide, incitement of genocide, and supporting the genocidaries that committed the actions of October 7th, that is Iran themselves. So if this treaty was built for anyone, it is in these circumstances. And your last question, to answer very simply, yes, there will be a magnifying glass to every action Israel is taking, every statement, every action. That includes with the Rafah coming up now with respect to the monthly reports and so on.
Thank you. Natasha, your views.
So briefly on the US, I think there definitely has been mixed messaging, which is deeply, deeply unhelpful. And that is a symptom of, the political landscape, upcoming elections. There was even an apology that was made on behalf of the administration. It was just leaked for its support of Israel to as part of the political campaigning, unfortunately, by, it seems, White House officials acting outside of their official capacity to the Arab community in America to apologize for the fact that America had been standing with Israel after the atrocities of the 7th of October. With respect to the OTT, over the top comment, I mean, so much of this is desperately confusing. I think it's still not clear from the context in which Biden was speaking, whether he was in fact talking about the Hamas demands in the context of the hostage negotiations or Israel's response. And even though we've had, throwaway comments like indiscriminate bombing, I think the ultimate position of the official spokespeople, when push comes to shove, is to recognize that even the United States probably wouldn't be in a position to take the measures that Israel has been taking to prevent civilian casualties. When their feet are held to the fire, that much is acknowledged and conceded, and nonetheless we have the unhelpful statements and the completely contradictory positions that are being taken, not least now with respect to Rafah. I mean, considering that the US has been fully behind Israel's war aims from the beginning of the war against Hamas, including the eradication of Hamas, I mean, did they really think that was going to be possible without an Israeli operation in Rafah? I wish that they would have looked at a map before issuing warnings and condemnations. Critical to this, though, is America actually taking up its international responsibilities and ensuring that other countries do likewise, in particular Egypt. Why it is that, since the 8th of October, there hasn't been an international clamour that Egypt comply with its own obligations under international law, under its the treaty that it signed, that it ratified in 1980, the African Union Convention on Refugees, which has a much broader definition of refugee than the International Refugee Convention, and includes those fleeing civil disorder. Every single Palestinian civilian that has presented themselves at the border with Egypt has been under an obligation to take those in, and it has been breaching that obligation for months now. We haven't heard a peep. And that indicates to me that, slightly going off slightly now, but just a final comment on that, it indicates to me that the international community, the Arab world here, they don't care a jot about the Palestinians or about Palestinian death counts. Because if they did, then the simplest thing would have been months ago to enable those Palestinian civilians to be properly cared for and provided with humanitarian assistance the other side of the Egyptian border in Rafah, on the Egyptian side, temporarily, while Israel was able to properly eradicate Hamas. The fact that we are now seeing a combined initiative, so international warnings about Israel continuing its operation in Rafah, and South Africa's new application to the ICJ vis-a-vis Rafah, it's in no way surprising that South Africa has made a further application to the court. It just has seized upon, the topic of the day and Rafah as a result of the international international discourse, and that again plays into why it is that South Africa is utilising, and I would say abusing, the court for these purposes. But in that context, I think it's pretty clear that Israel is stuck between a rock and a hard place, and despite the fact that it is complying, not only complying with its legal obligations in terms of the armed conflict, but going well above what is required under international humanitarian law, that's getting brushed aside. A case against Iran, I think, is an interesting concept. It should be seen in the context of a very interesting development last year, which was Iran rejoining the International Court of Justice's permanent jurisdiction. So signing itself back up to the court. Now, that was pretty telling, I think, for the direction of travel that Iran saw the ICJ moving in. And it doubtless would have accepted the jurisdiction of the court again in order to advance its own initiatives. But it does, of course, make it susceptible. What the end effect of a case against Iran might be, though, is not a big question, because organizations and institutions like the International Court of Justice, they work against law-abiding states that care if there are rulings made against them. Iran doesn't. It is the foremost state sponsor of terror in the world. And in the same way that Russia doesn't care about orders being made by the court against it, Iran won't either. So I'm afraid that there are very few potentially successful avenues for Israel to pursue in the international legal arena. And finally, in terms of what the court will look at, well, the court's going to look at what Israel presents to it. This is it's not an inquisitorial, civil law sort of system where the judges make their particular inquiry. Of course, the court will also look at what South Africa puts to it. But it will be up to Israel, unfortunately, to, some would say, prove its innocence. Technically, that's not how court proceedings should work, and it should be for South Africa to prove its case. But there is an important aspect of all of this, which is perhaps even more significant than the public relations side, and that is South Africa's motivation, or the motivation of all of the actors against Israel in international institutions, of putting forward the sorts of UN reports that were footnoted in South Africa's 84-page application to the court, the sorts of special rapporteur reports against Israel and NGO reports that have manufactured faux evidence and allegations of war crimes and now genocide against Israel. The purpose of putting these to the court is to seek a judicial stamp of approval on these documents so that they can be later used. This is all about the generation of evidence, essentially, faux evidence against Israel, so that they can later be used, be deployed by these negative actors and these NGOs that work for the destruction of the state of Israel and on behalf of terrorist organizations like Hamas. And so that they can be used specifically in domestic jurisdictions around the world. That has been a key factor of lawfare, and it is extremely evident in the context of the sort of material that South Africa had prepared long in advance. I mean, this wasn't an application that was put together overnight. This has taken a great deal of time, energy, effort, and planning. And there are going to be knock-on effects, not just with respect to the current war against Hamas, but very much further into the future.
Thank you, Natasha. Andrew Tucker, over to you.
Not sure I've got a lot to add after all of that. I'm finding it hard to get my mind around a Trump 2.0 world, what that would look like. The mind boggles, but it's possible, I guess. One thing that strikes me is, I mean, Trump is a deal maker. There's a big issue about what happens going forward. Let's say, for argument's sake, that, I mean, nobody knows how this war is going to end. Let's put this out there first, because how on earth do you actually eliminate Hamas? There is no way of telling whether you have actually eliminated Hamas, even in the Gaza Strip. So there's going to be a huge question about how do you determine when the war ends and you move into a new phase of somehow reconstructing Gaza. And maybe Trump is going to be the kind of guy who can pull the states of the Middle East together to create some kind of coalition that is going to be opposed to Iran and the reconstitution of Hamas. Iran will be doing everything it can to get money back into the Gaza Strip, to be reinventing Hamas, to be, getting Hamas back on its feet, also in the West Bank. So we need a leader that's going to be able to bring a coalition of states together that will oppose this. And I think the current administration actually has done a pretty good job of trying to build on Trump's legacy of the Abraham Accords. But I think he would put new energy into that. To come just back, my last comment is on Natasha's point, is an absolutely vital one about domestic jurisdictions. Arsen mentioned the case here in the Netherlands yesterday. The court, not the highest court in the country, but one of the important courts in The Hague, has decided that the Dutch government may not supply spare parts to the F-15 fighter jets that Israel has purchased from under the international regime. And the Netherlands plays a role in supplying spare parts. And the court, on the instigation of these NGOs that Natasha talked about, they mobilized these UN reports. And unfortunately, our courts are not equipped to deal with the complexities of international humanitarian law. These are judges who don't, so they're reliant on these UN reports, which create some kind of reality. And not only UN reports, but amnesty reports are treated as if they speak the truth. And the state, remarkably, the state of the Netherlands was put in a position it had to rebut the allegations made by the UN and Amnesty, as if it's so just turning the onus of proof on its head, really. It's a strange situation. The government is going to appeal it to the highest court in the country. We'll see what happens, but there's going to be a lot of this kind of domestic litigation pushed by NGOs, anti-Israel NGOs, to further delegitimize Israel.
Thank you, Andrew. We can take another 3 questions. Hugh Kitson, followed by Sharon Abramson, followed by Felix Ahrens. Hugh. You're on mute, Hugh.
Yes.
Thank you.
If I may, I'd like to ask a question about the advisory opinion that's before the ICJ. A lot of false information is being presented. I'm not quite sure what the ICJ is supposed to do, but a lot of false information is being presented to the ICJ based on what the UN has said. Could you give us some idea of some of that false information?
Thank you. Sharon. Sharon, you're on mute. Can you come off mute? Sharon? No, in which case, Felix, could you go next, please? Felix.
Sure. Thank you. I'll unmute. I was wondering about this whole focus on Iran, because in a sense, it's true, of course, that they are a very unhealthy actor in the region, but part of this all stems from an ideology that is very difficult to fight, that chooses to fight asymmetric warfare, of which they know that it's very difficult to defend against, both militarily and also in the court of public opinion, which is then reinforced by this lawfare, of course, because the whole purpose of asymmetric warfare is to blend individual criminal activity, which you could call terrorism, with say, something akin to kind of military operation, as Hamas then can continuously blend between the two. On the one hand, they can say, well, they are the military force of an ideology or of a movement of a peoples. On the other hand, they do things not in uniform and against which all these Geneva Conventions and so don't actually play a very clear role. So it's very difficult to uphold Geneva Convention and similar rule-inspired behavior, fighting terrorists who can basically, from the outset, blend in and move between those two scenes. That would be one question, and where I'm really concerned that we might get sucked up basically into only one aspect of that. Another question would be, would it be possible to pull Egypt, in this case, to legally into some responsibility to just absorb these refugees?
Okay, can we give them a chance to answer? Sharon, are you there by any chance?
Yes, I can unmute now. I couldn't before.
Okay, Sharon, over to you.
If I remember rightly, another one of the results of the court case was that they said that Hamas must release the hostages immediately. Now, this seemed to have been forgotten by the world within a few hours. Why doesn't Israel push on this? Why don't they speak for themselves, speak up?
Thank you, Sharon. I'm going to ask Arsen first, just to let you know that Arsen needs to leave shortly after 8 o'clock. So that's why I'm asking him to speak first. And then I'll ask Natasha and Andrew. Arsen.
I appreciate that. Look, regarding the hostages, I think that is important. I think there are two important things we do need to bear in mind also with respect to the judgment itself, and that sort of, it really sort of depends then on how one looks at the overall impact of it. The one thing that South Africa wanted the most in this judgment was a declaration of a ceasefire or a halt to Israel's military operations. They did not get that. Okay, so notwithstanding all the very disturbing and one-sided and biased findings that were made, South Africa did not get the one thing which they really sought, and that was the halt to military operations, number one. Number two, yes, you are right, there was a reference to the hostages. However, it makes a difference to the way it was phrased. It wasn't a demand on Hamas to release hostages, but it was more, I think, in the context of that we express concern and call something like that on hostages to be released, as opposed to an actual obligation upon Hamas to do so. With respect to one of the earlier questions with the asymmetrical nature of the warfare, you're right. It is very difficult to uphold international law against a bloodthirsty terrorist jihadist enemy that wantonly massacres, burns, rapes, mutilates, and abducts children, women, Holocaust survivors, elderly, innocent people. This is an entity that has breached and violated every imaginable and conceivable international law and norm that there is. So, thinking that the Hamas will at any point decide that, yes, we will follow the Geneva Conventions or the like is, an absurd proposition. They won't even allow the Red Cross into Gaza to visit the hostages, and it's been almost 130 days now. So I think this is this does highlight the challenge of in the international legal framework, the very framework that was developed in the wake of the Holocaust, by the way, and the Nuremberg laws to describe the very atrocities that we saw then, and which in some ways, many ways, people are saying, rightfully so, I believe, that are repeating again today. So it is very difficult to hold necessarily Hamas responsible legally. Militarily, we certainly can. But I think equally important here is that even though we might not be able to hold Hamas legally liable or hold them in before the courts, those that enable them, those that fund them, those that support them, those that encourage them, aid them, and abet them, then we can hold liable. That includes South Africa. The UK has bilateral relations with South Africa, as does the US. The US is, in fact, putting forward bipartisan legislation to review its relations with South Africa, including that $25 billion plus in trade. It does include options of holding those accountable that fund and finance these kinds of actions as well. The UK might follow Germany's position here, which not only condemned this subversion and politicization of the proceedings, but actually said they will step in as a party to the proceedings in support of Israel. So whilst it might be difficult to hold Hamas liable in a court of law, we can certainly hold those that enable them. And then, by the way, also banks and in civil courts as well, and taking other actions which can prevent and harm and impair their abilities to carry out these acts.
Andrew and then Natasha. Andrew.
Thank you so much. Am I on mute? No. So let me answer my dear friend Hugh Kitson's excellent question about the false information. I was just looking up while you were talking. You can see on the website of the International Court of Justice, under this case of the advisory opinion, they've published all the information that's being provided by the United Nations itself. And this is really done by the UN Secretariat. Okay, so you have to understand the Secretary General of the United Nations is deeply embedded in this anti-Israel narrative. And he holds the keys to a myriad of organizations and committees and councils within the UN that are generating these reports. Their General Assembly committees, there's the Committee on the Inalienable Rights of the Palestinian People, there's the Human Rights Council's Commission of Inquiry and special rapporteurs and so forth and so on. And he channels all this information. There's a list of 1,400 documents that they've provided to the court. So that's just the UN information. And then you have 55 states who have voluntarily elected to participate in these proceedings, right? So every one of the 193 member states has a right to participate in these proceedings. 55 have elected to do so. Of those 55, I would say 50 are rabidly anti-Israel states. So they have all provided written statements and written observations to the court justifying the position that Israel is violating international law, is violating the rights of the Palestinian people to self-determination, that the occupation has become illegal, and so forth. Oh, by the way, one of the parts of the question that the court has been asked to answer is not only the occupation, but the status of the holy city of Jerusalem. This is a little phrase within the question that people overlook, but this court has been invited to make a determination not only about East Jerusalem, but about the city of Jerusalem as a whole. And many of the submissions are likely to be putting the case that all of Jerusalem is somehow occupied or does not belong to the state of Israel. So all of this to say there's very few states. So you have 3 international organizations presenting the Palestinian narrative: the Organization of Islamic Cooperation, the League of Arab States, and the African Union. They've all provided mountains of documentation to the court. And these judges, many of them, they don't know the history of Palestine. Or if they do, they know a narrative that is not friendly to the Jewish people. Let's not forget the president of the court is a Lebanese lawyer who has made many comments in the past supporting the Palestinians against Israel. So we can't expect this court's going to see through all of this to see the truth. So that takes me back to perhaps to Arsen's earlier comment about those opportunities there are to speak to the court are really opportunities to speak to the world. This court has really become a show, kind of a circus. Don't like to use that word, but it's not a court of law anymore. It's become a political place where people put political and not legal positions, unfortunately.
Thank you. Natasha.
Just to pick up on that last point from Andrew, and to relay some of the discussions I've been privy to amongst the great and the good of the international legal world, who've celebrated this order of the court and said what a jolly good job the US Justice, the president of the court, Donoghue, did in crafting a document that nearly everyone was able to sign up to. And I have to say that I have been astounded by that position, which is what you would expect from the sort of diplomatic negotiations and in passing a resolution in the UN, not from a court of law. And what the dissenting opinion does, I think, extremely articulately and clearly, is set out the approach that a court of law ought to have adopted here, in terms of applying the law to the facts and the tests that are relevant in terms of plausibility and for provisional measures. And the court plainly hasn't done that. It has crafted a document as a diplomatic exercise in order to try and get as many of the justices to sign on as possible. And in doing so, it has created, as I mentioned earlier, this empty vessel. But it has, unfortunately, I think, laid the groundwork for a great deal more of abuse of the International Court of Justice, and South Africa's most recent application, RAFA, is a case in point on that. What the court isn't able to do is order Hamas to do anything. There was a reference to the hostages and a hope that they would be released, and in fact the dissenting judge Sebutinde remarked on the seemingly close relationship that South Africa seemed to enjoy with Hamas, and suggested it might be a good idea if they would use their leverage on Hamas to secure the release of the hostages. But the farcical element of this is that the court, of course, has absolutely no power over the internationally prescribed terrorist organization that is Hamas, and only law-abiding states are going to take note of whatever the court orders eventually. So far as the responsibilities of other countries and holding Hamas to account in other contexts, so far as that is concerned, I mean, there are definitely international legal responsibilities on states, for example, under the binding UN Security Council Resolution 1373 to combat terror funding and support for terror organizations around the world. And if that were to be applied properly, doubtless many states would find themselves on the wrong side of that, not just with respect to Hamas, but let's not forget that the 7th of October atrocities were also committed by members of the Popular Front for the Liberation of Palestine, by the Palestinian Islamic Jihad, by Fatah, and supported by the Palestinian Authority, who continue to pay the salaries of the terrorists that orchestrated, planned, carried out the 7th of October massacre. Of course, also under the Genocide Convention, all member states are required to punish and prevent, and every effort should be made to focus their attention on the real acts of genocide that were perpetrated by Hamas and other Palestinian terrorist organizations, and those that they threaten to repeat over and over. So far as the difficulties of upholding international law, specifically international humanitarian law, when fighting a terrorist organization that uses its breaches of international humanitarian law as part of its modus operandi against Israel. So Hamas's use of human shields is firstly to succeed in driving up the civilian casualty count as far as it possibly can, and secondly, to frustrate Israel's options in conducting lawful strikes against terrorist infrastructure, because Israel, as a law-abiding state, is conducting a proportionality analysis which is completely skewed when it doesn't want to fire against legitimate targets because there are too many civilians in the way. Nevertheless, Israel does. And I just want to pick up briefly on why that is, because so much of the discussion in the context of international law and the requirements, and there are definitely processes, including the Military Advocate General Corps procedures and selecting targets for strikes and approving them in advance, and the legal mechanisms in the IDF are well known to other law-abiding states that have often visited and taken notes and sought to learn from the processes that Israel has developed. But there is another factor here that is never discussed, and that is the IDF ethical code, the purity of arms, the code of ethics, and the impact that being a citizen army has. Because the vast majority of those that have engaged Hamas terrorists in the Gaza Strip over the last few months, Yes, there is a professional army, but we've had over 300 reservists join. Some of them didn't even wait to be called, join to defend their country in these dire circumstances. And these are ordinary people belonging to democracy, the democracy that Israel is, that have been educated in the democratic values, the values of life, as opposed to those that are taught by the Palestinian terrorist organizations that prize death over all. And that is critical when it comes to making an assessment about Israel's approach and Israel's conduct. And you see it, stories coming out of the current operation and reports by those who have been serving, example upon example of Israel going over and above to protect Palestinian civilians and call off strikes if they are in doubt because of that moral compass and ethical code. Which definitely there needs to be more discussion about. So far as defeating Hamas is concerned, this is something that's also come up. Absolutely, it needs to be done militarily in the immediate term, and that is to take out Hamas terror infrastructure, even if it is supported by the UN. As we saw, the data center was discovered under the UNRWA headquarters in the Gaza Strip, both supported in terms of the electricity supply and the internet that they got from UNRWA and the cover that UNRWA provided. But the critical aspect of defeating Hamas after the war is going to be denazification. And that is a process that the international community have to get on board with, and they have to get on board with it quickly. And that involves recognizing how they have been in breach of their international legal obligations, including for the combating of terrorism, by continuing to fund the indoctrination process that ultimately culminated in 3,000 terrorists crossing the border and committing those atrocities. You don't create people with the capacity to do that sort of thing to other human beings overnight. You do it through 30 years of indoctrination, through UNRWA-run schools, and that's something that needs to be addressed. Just lastly, finally, in terms of the advisory opinion, absolutely, shed loads of false information, and this is something, in fact, that has been addressed in a submission made by UK Lawyers for Israel, written by UK Lawyers for Israel, and submitted jointly with the ELNET organisation, that highlighted the real problems with the court's previous advisory opinion in 2004, which was made on the basis of false, misleading, and only partial information. And the position put forward to the court in that document is that it simply does not have the appropriate information to make the conclusions, to draw the conclusions, and to give the opinion that is being sought of it. And it's asked, therefore, to stay well away.
Okay, thank you very much indeed, Natasha. That concludes the questions, as we're now out of time. Two things still to do. First, I'm going to ask one of our members, Denise Lester, to speak for a moment about the Lovelock project, which JW3 are working on. I think you'll just need to know about this and support the hostages in that regard. And after Denise has spoken, I'm going to ask our Vice Chairman, Keith Rowe, to propose a vote of thanks for the speakers. Denise.
Thank you very much, Gary. To everybody who is on this link, this very important link, including our learned lawyers and their family and friends, you may or may not be aware of the Lovelock Bridge installation, which went live and was incepted on Sunday. It's a project by Marcel Noble, and it comprises of padlocks with messages on them of support for the hostages and their family. And the purpose is not only symbolic, but it's also to change the tide of media consciousness and to keep in the eyes of the media the Bring the Hostages Home campaign, which we all want. And I would urge you, please, I'm an old friend, long-standing friend of Marcel's, please to go along to JW3, pick up a padlock or take your own, write a message, and place it on the bridge. You can do so during the day and the evenings. Marcel's is there during the evenings. If you live out of London, JW3 have kindly agreed, and there are padlocks in the reception, but JWA have kindly agreed that if you send the padlock in the post to the Lovelock bridge at the JW3's address, they will accept it. If you want to put a message on the padlock and your email, Marcel will hopefully arrange for there to be a photograph of it being put on the bridge. The aim is to fill up both sides of the wiring and completely fill the bridge. And so the more, please, people that you can spread out through your various networks, the better, please, in this very good cause. Thank you. Thank
you, Denise. And can I urge us all to do this? It's important to show our support for the hostages and a terrible plight they're going through. Now, it just remains me to ask Keith Rowe, our Vice Chairman, to propose a vote of thanks. Keith.
Thank you, Gary. And on behalf of the NJA, I would like to thank all of our three guest speakers for being with us this evening. You've covered between you a huge amount of detail from slightly different angles. Andrew started by giving us some of the historical background and the rebranding of the Palestinian cause. Natasha, thank you again for being with us. You've been with us before, so thank you for addressing us again this evening and for explaining to non-legal minds such as mine the processes involved of the court and the political reasons behind it all. You make it all very clear to people like myself, and it's really helped. Thank you. And Arsen, we haven't spoken before, but I've been retweeting you for a long time, so it's nice to actually get a chance to hear you in person, and for your initial introduction explaining some of the hypocrisy of Hamas calling for genocide and accusing Israel of doing exactly the same, explaining about how the United Nations is a tool of Hamas. And then, of course, we've gone from that, and all three of you have explained in with a huge amount of detail answers to the questions from a huge range of topics, everything from spare parts for F-16 jets through to all the Hamas infrastructure. There's an awful lot for us to take in, but it's been hugely informative. Thank you all for being with us this evening. I do hope that we'll see you all again on different sessions, because we need to be kept up to date by people so closely to the detail of these things as all three of you are. It's much appreciated. It's been a great and informative evening. Thank you very much.
Thank you all very much. Have a lovely evening. Good night.
Thank you.
Thank you.